Losing a loved one is one of the most difficult experiences a family can go through. Amidst the grief and the memories, there is often a necessary legal process waiting in the wings: probate.
But what happens when the final wishes left behind in a will are called into question? The period following a loss is emotionally fragile. Discovering that a will might not truly reflect what your loved one wanted can shatter a family's peace. Challenging a will, known as a probate contest, is a complex journey intertwining the deep pain of loss with the overwhelming maze of the legal system. Today, we will explore the common reasons probate gets contested and, crucially, how you can prevent these painful disputes from happening to your family. Losing a loved one is difficult, and the legal aftermath often adds to the stress. This process is called probate. Simply put, probate is the legal procedure that verifies a will and ensures a person's final wishes are carried out. The journey begins when a will is submitted to the court. The judge validates the document, the executor pays off any remaining debts, and finally, the remaining assets are distributed to the heirs. While probate provides essential oversight to protect an estate, it can be a lengthy and complex process. Unfortunately, this formal legal journey is exactly where disputes and will contests most frequently happen. As the years pass, the sharp minds we once knew can sometimes begin to fade. In the world of estate planning, this reality leads to one of the most common reasons a will is contested: a lack of testamentary capacity. Testamentary capacity means that at the exact moment a will was signed, the person fully understood what they were doing. They must comprehend what property they own, who their natural heirs are, and how the document distributes those assets. Challengers usually rely on medical records or eyewitness testimony to prove their case. Severe dementia, Alzheimer's disease, or advanced illnesses requiring mind-altering medications are frequent grounds for these disputes. Even sudden, drastic changes to a will shortly before death raise major red flags. Challenging a will on these grounds is a complex legal battle. It requires concrete evidence that cognitive decline directly impaired the person's judgment on the very day the document was executed. If the judge agrees that capacity was lost, the entire will could be thrown out, leaving the life savings to be divided by a previous will or default state laws. When a loved one passes away, discovering sudden, unexplained changes to their will can feel like a betrayal. But what happens when those changes weren't truly their choice? This brings us to one of the most common and complex reasons for probate disputes: undue influence. Undue influence is more than just nagging or mere persuasion. It happens when someone exerts such intense pressure or manipulation on a vulnerable person that it completely overrides their free will. The resulting legal documents reflect the desires of the influencer, not the deceased. This type of coercion often occurs in the shadows. We typically see it involving an abusive caregiver, a sudden new romantic partner, or a highly manipulative family member. By slowly isolating the elderly individual from their support network, the influencer gains control. They dictate who can visit, intercept phone calls, and eventually guide the pen to alter the estate plan. Proving undue influence is a monumental challenge, primarily because the central witness is no longer here to tell their story. The deception usually comes to light during the probate process, when a locked safe or strongbox is finally opened, revealing a drastically altered will that inexplicably leaves everything to the manipulator. Creating a will is just the first step. If strict legal requirements for execution are not followed to the letter, the entire document could be thrown out. The most common reason a will gets contested is simple human error during the signing process. For a will to be legally binding, the testator must sign it in the presence of at least 2 disinterested witnesses. Those witnesses must then sign the document themselves, confirming they watched the testator sign. If a witness was out of the room during the signing, or if only one witness was present, the will is vulnerable. Even a missing date or an uninitiated correction can open the door to legal challenges that drain the estate. To avoid these devastating mistakes, always have an experienced estate planning attorney oversee the execution of your will. They ensure every signature, date, and initial is perfectly placed, leaving no room for a costly courtroom battle down the line. Don't let a tiny detail ruin your family's future. While some disputes arise from simple misunderstandings, others are born from outright deception. Fraud and forgery are among the most serious grounds for contesting a will in probate court. Fraud occurs when someone intentionally misrepresents facts to deceive the testator into signing a document they wouldn't have otherwise agreed to. For instance, tricking an elderly parent into signing a will by claiming it's just a routine medical form. Forgery, on the other hand, involves creating a fake document or altering an existing one after it was created. This often takes the form of falsifying the deceased's signature or swapping out pages of the original will to change the beneficiaries. Uncovering these deceptive tactics usually requires hard evidence, such as testimony from handwriting experts or witnesses. If the court determines the will is fraudulent or forged, it will be invalidated entirely. When this happens, the estate is typically distributed according to a previous valid will, or if none exists, by the state's intestacy laws. To understand how these disputes play out, let us look at real-world scenarios from the courts. In one notable case, an elderly gentleman altered his will just weeks before his passing, entirely disinheriting his children in favor of a new acquaintance. This classic example of undue influence triggered a massive, multi-year legal battle, draining the estate's resources. In another frequent scenario, a mother diagnosed with severe dementia updated her estate plan, sparking a fierce challenge from her heirs over her testamentary capacity. A judge ultimately invalidated the new will based on her medical records. These heartbreaking cases highlight a crucial lesson. Proactive planning, proper medical documentation, and transparent communication are your best defenses against a courtroom battle over your legacy. At the end of the day, estate planning is about protecting your legacy and ensuring your family's future remains harmonious after you are gone. To minimize the risks of a contested probate, there are a few proactive steps you can take. First, review your will regularly, updating it after major life events like marriages or the birth of a child. Second, communicate clearly with your beneficiaries about your intentions to prevent any sudden surprises. Third, choose a capable and impartial executor who can handle the responsibilities without conflict. Finally, always seek professional legal help. Consulting an experienced estate planning attorney ensures your documents are legally sound and properly witnessed. By taking these strategic steps, you can secure your legacy and give your loved ones true peace of mind. Securing your legacy doesn't have to be a source of stress or conflict for your loved ones. By taking the time for thoughtful, clear estate planning today, you ensure peace of mind for tomorrow. Thank you for watching. For more resources, guidance, and support on estate planning and end-of-life matters, visit us at funeralus.com. If you found this video helpful, please give it a thumbs up, leave a comment below, and subscribe to our channel for more insights. Take care.